car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Hello and welcome to the attorneys. I'm Art Franklin, and we're going to dive into what can be a complicated topic of wills and estates, but we're going to break it all down for you. But before we get to that topic, I want to remind you that attorneys at Hollis Wright are standing by right now to take your calls. 1-844-LAW-TALK. It's a free and confidential call. Go ahead and get in contact with them. They'll be manning those phones throughout this show. So Carter, let's get into this topic of wills and estates.
Yeah, not only can it be complicated, it can also be emotionally charged under various circumstances. Someone passes away, you and your family members are going through the grieving process, but at some point thereafter, you're going to have to address the issue of what happens to the decedent's property or assets when they pass away. And really what it comes down to is control and intentions. And we're going to talk about the importance of having a will, and why that is so important is because it allows you to have control and intentionality about where your assets go. Obviously, if you've got property, you've got money, you've got assets, you want those items or assets to go where you intend for them to go. The will is the best way to do that. Joy Travis is here with us. Joy, thank you so much for being with us here tonight.
Absolutely. Thanks for having me.
Yeah, I know this is an area that you focus on in your legal practice, but tell us a little bit about yourself, Joy Travis, and your area of legal practice.
Sure. So I am a practicing attorney. I have a firm that deals with probate, family, and criminal. We do things that affect families pretty much. I've been practicing in this field for about 7 years, and I've been able to really work with different entities. The probate court and all things related. Mental health is directly related to probate. So things that people don't necessarily think at the onset are related to probate really have a big effect on what we do when we prepare for things like death and being intentional about our assets.
Yeah. Talk about the importance of the will, the control that you have over the will, and what happens if someone dies without a will.
So if someone dies without a will, they're basically dying, it's called intestate, and they're dying without any type of expectation of where their assets will go. And of course there is law around that will kind of give you that guidance and tell you what should happen with your assets. But if you don't have a will, then typically the courts are going to make that determination of what happens if there are some assets in your estate or some sizable things in your estate that can't be figured out, but also they have to follow the law. The will is always a good option to have, because with the will it allows you to be able to be intentional about what it is that you want your assets to be conveyed to, or who is going to be responsible for what at your demise. And people don't realize sometimes that, you know, assets are your house, assets are your car, bank accounts and things of that nature. And in some instances, you know, if unfortunately if you die under a circumstance where you could come into a sizable amount of assets, then that needs to be some type of direction about what needs to be done if you are passed away and you have a large amount of assets. So the will helps bring that guidance and says who's supposed to manage your affairs at your death, also who's supposed to take from your assets at your death. So it's very intentional. We want to plan and make sure those things are in place before something happens.
I had someone one time in your area of law very succinctly put it to me this way. He said, if you don't create a will, the state of Alabama has created one for you.
Correct.
And the problem, though, is that the Alabama law or will is a one-size-fits-all, meaning there's no deviation. It says exactly, if you've got these assets, this is who is getting your assets, whereas if you create your own will, you've got control over it. And I think the best way to illustrate some examples of horror stories that I have seen in my practice, you probably have seen as well, as I've had situations, and really this comes into play in personal injury related matters where somebody dies after they were injured in an accident. But we've seen situations where a couple was married, they separated, but they never got formally divorced. They didn't have a will, so when one of them dies, well, guess what? the person that you had intended to get divorced from several years ago that you don't like, that you don't want to get anything, they're getting the lion's share of your assets, correct?
Well, yeah, and not only that, but they're making decisions about if you are medically in a position where you can't make decisions for yourself. And then there are other assets that you have to consider. You know, a will talks about what to do with assets like cars and money, but if you have life insurance and 401ks, if you don't designate a beneficiary, you know, more than likely, they're just going to go with who you're married to, even if you're separated. So that's really, really important to take care of your affairs.
And the same goes for children. You've got 2 or 3 children, one of which you have a very poor relationship with. They abandoned you many, many years ago. They moved out to California. You hadn't even talked to them. Well, guess what? If you don't have a will to account for your assets, that child that you had a bad relationship with, they're getting a percentage of your assets.
They are.
Yeah.
They are.
And something else, Joy, is a lot of people don't talk about whether there's a will, whether there's a trust, what, you know, where I want my assets to go. How do you even know if a will exists, but that your loved one even has a will?
Yeah, and typically when I am working with clients to develop wills, I always tell them that I'm going to house a copy of that within my law firm, right? But I also tell them to please let the people that are in the will know that this will exist, you know, and it's not a bad idea sometimes to even give them a copy of it. You know, when you probate a will, you're going to need to probate the original copy, but if something happens to the original copy, if someone has a copy of it, at least there's some evidence that this will at least existed. So my suggestion to people and my clients that I service are to at least make copies and let people know in the will that they're a part of it. And sometimes you don't want to do that, but at least your executor, you know, or someone that's going to handle your affairs for you, at least let them know, put it in a safe place. You know, I know sometimes people would like to go down to probate court and file their will in, and I think the probate court is kind of not encouraging that as much nowadays. But there are still things that you can do, have everything in a safe place. I know I see now a lot of folders that say important documents or things like that that you can just put under your bed, so if something happens, not only have the will in place, a copy of your driver's license, copy of your bank accounts, maybe a copy of your insurance policies, because if something happens to you, that's the last thing someone is trying to do is figure out all these different things and where to go and who to call. And, you know, if they're all in a place where they can get to them, it makes it a little easier to handle your affairs.
Yeah, I think having a copy of it with the law firm, the lawyer that helped draft the will, is very important. You have safety deposit boxes at the banks. You can keep that amongst other important documents and things in your life there. But that's a great idea. Yeah, you don't want all your heirs or family members to be scratching their heads asking, well, did mom or dad have a will? Like, how do we go about trying to find it?
But as a follow-up to that, though, Carter, you saw that situation with Aretha Franklin. Where there were so many wills, there were multiple wills, and then it becomes a big court issue, right?
Yeah, and you know, typically when you make a will, the most recent will you make is going to extinguish the other ones before that, right? And that's typically what you expect to happen. So you're not expecting people to hold on to other wills, and if you consistently work with one attorney to do these things for you, they should kind of guide you on that and then get rid of those other wills. So that's pretty important.
Well, those will contests, that's really how Joy Travis probably makes her living, because, you know, if everything goes smoothly and but the will contest, I mean, we don't have too much time for this particular show to talk about it, but diminished capacity, incompetence, people trying to get their loved one on their deathbed to sign another will to the detriment of another family member. So these are all the types of issues that come up, but that's why it's so important that you have somebody like Joy Travis working with you, developing, fine-tuning that will to make sure that it can't be disputed down the road.
Exactly. We're talking with Joy Travis. We're going to continue that conversation as we're talking about wills and also estates. Thank you so much for joining us. I want to remind you, there's a QR code on your screen. If you go ahead and scan that QR code, you can get in contact with Hollis Wright. We're going to take a break. We'll continue this discussion and more. Stick around. The attorneys will be right back after this.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, Call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas such as bankruptcy, criminal law, civil law such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Honestly, we don't love all the legal advertising we see, but some firms are simply built different. If you want a firm you can be proud of, one that doesn't stop until we win, well, you found it. Let Hollis Wright tell your comeback story.
We are talking wills on this edition of The Attorneys, and so glad to have you joining us. Also want to remind you, you can always follow Hollis Wright on every social media platform that's out there, whether it's X, Instagram, Facebook, YouTube, also TikTok. You'll find Hollis right there, and you can get that information and great content throughout the week as we are constantly posting things there. But we're talking with Joy Travis, and we want to continue this conversation on wills.
Yeah, if somebody has a will, are all assets flowed through the will, or are there ways in which the assets can be distributed or disposed of outside the will, and how does that work?
So there are things that can be done in order to make sure that maybe everything doesn't have to go through probate. For an example, if there is a deed, if people are married, or the deed has a survivorship option on it, then that might not necessarily have to go through probate for you to have to be able to pass that down or convey it to the person that gets that survivorship right. If you're talking about, your beneficiaries.
Like life insurance beneficiary?
Life insurance, 401ks, things like that. You always have to make sure you have a designation on those beneficiary documents. And one thing that I've run into recently is making sure you have a copy of that beneficiary designation form, because I have seen sometimes where there's not on a record, the insurance company doesn't have it, and that causes some type of issue as well. So where you keep those important documents, make sure you have the form of the beneficiary designation, because with that you can designate, a certain percentage to different people, your spouses, your children, and so that's really important. Also making sure on your bank accounts there's a payable upon death. That makes things a little easier, because I know sometimes when people pass away, they can't access funds to be able to handle affairs or whatever needs to be done, and they're like, they need something from the probate court. Well, if there's a payable upon death, that person is actually the beneficiary of that bank account. Yeah. So there are some things that can be done to kind of be proactive with the steps of someone passes away, to make sure you still have access, or you don't have to necessarily open an estate to handle some of the matters or handle some of those assets of the decedent.
Yeah, that's really important, because I've oftentimes wondered, people get confused about, well, what do I do if my mom or my dad, they had a mortgage on the house, or they've got utility bills and power bills and things that are coming in even after they pass away. I don't have the money necessarily to pay for these bills. What happens? And so if I'm understanding you correctly, you can actually designate a bank account or a life insurance policy payable upon death, or to a beneficiary, where literally they can go to the bank or go to the life insurance company and say, hey, here's the designated beneficiary. I'm the designated beneficiary. You can get that money within 20 or 30 days to be able to pay for those bills.
Correct. As long as you have the death certificate, and that's why it's good to have a copy of that beneficiary form with your will, with a copy of your driver's license, because your important documents are going to be needed. And it's really important, because because you just never know where you're going to come into that situation where you might need to be able to have those documents. Sometimes I hear people say, well, I have a power of attorney. The power of attorney dies when the person dies, right? And so that might have been that person's intent when they're alive, but if they're not plans after they're deceased, then it puts you into a little stickier situation.
Yeah. For assets that have to be disposed of through the will.
Yes.
So in other words, they have to be probated. What does that process look like? It's kind of from start to finish.
So one thing to remember too is that, just because someone passes away, debt does not die with the person. And so
I wish that was the case.
I know. Most people do, but like you said, these bills are still coming, things need to be paid. If you're going to open up an estate to transfer assets, one of the key things to remember is that it's not a quick process. Legally, you have to keep that estate open for at least 6 months. And then the other thing to consider is that once you open an estate, you're exposing yourself to any creditors that might be out there. So if someone passes away and they have a mortgage, that mortgage is still due. And if you open up an estate, that mortgage company is going to look to see if an estate is open because they're going to file their claim because they want their money. There are things like insurance that can help to pay your mortgage off when you pass away. So being proactive and having some of those things in place beforehand kind of helps so if someone has to handle your affairs at your death.
Yeah, and as I understand it, one of the reasons they have that sort of 6-month minimum time frame that the estate has to be open is so that they can give creditors, mortgage company, credit card companies, the opportunity to file a claim with the probate court saying, hey, we're owed this debt out of these funds. And there's a process to that. You have to give notification and that kind of thing to people in the general public, to creditors, to give them notice that, hey, this person died who had this credit card. Let's say, for instance, if you want to make a claim on their estate, you better come and do it.
Yes, and so typically when you open up that estate, publication will run. It's going to be notice put out there that, hey, this estate is open. So if someone has a claim, they have the opportunity to file. And so that's really important to know because I think sometimes people think, well, I'm just going to open the estate to get the authority, but you could be opening up a can of worms. Unfortunately, even if you're focusing on one thing, 10 other things may come up. And so I always tell people, they're like, I can do it myself. If it's a sizable estate, you might want to get help with it. If there's, a house or a car and you want to figure it out, I get it. But if there are some things in the estate, a big amount of money or things that are just in question, or there are a lot of heirs to the estate, you want to get an attorney to help you with those things because there is law specifically that sets out for what to regulate and how these things are supposed to pan out.
Well, Jordan, I'm thinking about this. It sounds kind of morbid, but we have to start planning because what you're talking about really involves some long-range planning on the front end. So what types of things can I do to prepare for my death?
Well, first of all, have a will. Right, and but not only have a will, have a conversation with those important to you about your will and maybe what's in it. One thing people don't think about sometimes is even on your iPhone, you have a legacy contact, right? So you can add that person that can be able to access your phone at your death, and that's really important. But not only having a will, but having a plan. Maybe having burial insurance or planning out what your funeral will look like. It's not too uncommon to plan these things out before death happens, just to make sure they're in place. And then having all of your important documents, the driver's license, the will, copies of your life insurance, any beneficiary designations, in some type of envelope or important folder that's in your home that maybe one person knows about so they can access it. That's the best way to start planning and making sure you have what you need if something happens to you.
I know it depends on the complexities of the person's situations, but cost is always a factor in this.
Cost is always a factor.
What is sort of the garden variety cost to get a bare bones will and kind of start from there?
Yeah, so I get that question a lot. People are like, well, how much is a will? And my next response is, well, how many assets do you have? Basically it's based off that. If you have a will and you just want everything to go to one person, cost will probably be a little bit more affordable as opposed to if you have 20 items in your home that you want to designate to someone, then you're going to kind of get into more pages. So typically people look at the number of assets or the amount of pages it may take to designate all of those assets to someone.
Yeah, in the grand scheme of things, though, what the viewers are going to find is that it's very cost effective to have a will if you've got any assets out there that you want to protect and dispose of under the circumstances, and it will eliminate a whole lot of headache and stress for your family members if you've got that will in place.
Yes.
Indeed, Joy Travis with us as we're talking about wills, and also want to remind you that you can get in contact with Hollis Wright. Got just a little bit more time to reach an attorney while we are still on the air here with the show. All you have to do is call 1-844-LAW-TALK, 1-844-LAW-TALK, and then you will get an attorney on the other end of that line. It is a free and confidential call. We're going to wrap things up when we come back. Stay with us. You're watching The Attorneys.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon. I've always heard, surround yourself in life with people that fight for you in rooms you're not in. That's what we do for our clients every single day. Hire a firm ready to advocate for you. Let Hollis Wright tell your comeback story.
And welcome back to The Attorneys. In addition to having a guest on, we like to give you information, and you probably see some information scrolling at the bottom of your screen. Want to let you know, here's a fact of what we're talking about right now. An estate must stay open for at least 6 months before it can be closed. That's one of the facts of talking about wills as we continue on with Joy Travis here now.
Yeah, we've got a viewer question here, Joy, for you involving a loved one being at a nursing home and passing away, and the viewer believes that their loved one who passed away was victimized by some type of negligence in the nursing home. In those types of situations, what do you recommend that the heirs do?
I recommend the heirs get an attorney immediately.
Yeah.
You know, especially in those types of situations, time is of the essence. I know your firm handles things like that, but those are very, very important because you don't want evidence to get away from us, and time is of the essence with those.
Right, and in a lot of these situations, an autopsy might even be required to determine exactly what the cause of death is. Determining what happened is very important as well, getting those records, basically talking with witnesses. You really want to jump on these pretty quickly while it's fresh in everybody's minds, but of course you're also going through the funeral, the ceremony, you're grieving the passing of a loved one, so it can be difficult, but yeah, jumping on those quickly can be very important, but talking with a lawyer, we don't charge anything.
Right.
So it doesn't hurt to call, have a 15-minute, 30-minute conversation with a lawyer at our firm or any lawyer that handles those types of cases is definitely something that they should consider.
Yeah, because once time gets away, you know, it's harder to try to get medical records and just kind of go backwards. And, you know, attorneys, of course, we know what to do to make sure that evidence is salvaged, right? And so that it's not destroyed. And so there are some things that, you know, needs to be done immediately. Just let the attorney handle it because you're dealing with grief with the deceased loved one at that time anyway.
Yeah. What are the responsibilities of an executor? And let's unpack that just a little bit. So if somebody dies without a will, they're either going to be an administrator, which is the male, or the administratrix, which is the female.
Correct.
If you die with a will, the representative will be the executor, male, executrix, female.
Correct.
So just to make sure the viewers understand the terminology, if somebody dies with a will and they've got a male representative, he's the executor, what are the responsibilities of the executor in processing all of the assets and going through the probate court?
Well, the executor has a really important role. The executor basically is handling the assets of that estate. And when handling them, they have to be accountable for them. So there has to be an inventory taken. You know, you have to communicate with the heirs so that they know whoever is supposed to receive something, they get that and they know what they're supposed to receive. You have to know that bounty. You have to know exactly what is in the estate or what should be there. You know, whether bank accounts or cars, whatever the case is, you have to know what it is. is. And just being able to communicate and understand the process of making sure you're following the law or following that will and what the expectation of the decedent was. But the accounting question is the biggest one I get all the time. You have to keep accurate records, and you're not supposed to use funds from that estate for your own personal privileges. You know, they're only for expenses of the estate. You know, if you're going to sell a home, you have to account for that, every single penny, and it has to go back inside the estate so that it can be accounted for, and that would be part of that accounting.
Yeah, I'm going to guess that allegations of mishandling or misappropriating of funds, and also my brother or sister, who is the executor or executrix, they won't talk to me.
Right.
I don't know what's going on. Those are probably two things that you see quite often in your practice.
I get it all the time, and it's really important if you don't know how to handle it and manage it. That's why it's so important to get an attorney, because just because you're named in the will, it gives you the authority, but you have to know the process. And heirs have the right to know what is going on or what they're supposed to receive, and if they don't receive it, they should know why.
Yeah. Really simply put, the executor's responsibility is to get their hands or arms around all of the assets that are out there, identify everything, do what they need to do to put a value on those things, and also get their arms around the debt that is being claimed by credit card companies, mortgage companies, and simply put, you're going to pay off all that debt out of the estate, and what's left will go to the heirs in accordance with the will.
But sometimes, unfortunately, there's not money to pay off debt. Right, and sometimes you might have to sell some things to pay that debt off, because the debt has to be paid. And so that's really important to know too. If there's money in the estate or the account and there's debt as well, you don't just pay out. You have to make sure the debt is resolved before there's some type of payment made funds.
We always often talk about the need for having an attorney. Well, you should get one from Hollis, Wright, or get you as an attorney. What about opening up an estate? Do I have to have an attorney to open up an estate?
Well, you don't legally and technically have to have an attorney, but if you don't know what you're doing, I definitely would encourage at least get some legal advice. You know, sometimes people think that it's going to be cost prohibitive, right? It's going to be too involved, but you don't know. And so just to even get a consultation with an attorney, because the attorney might say, hey, you know, pretty much this is all you need to do. Unfortunately, at probate court, they're not going to give legal advice. You know, they're not going to tell you this is what you do, this is what you do. And we know good old Google is just not as concise and legal as we need it to be. So sometimes it's best maybe to ask someone that's gone through the process before, someone that you know that has had to be an executor of an estate or deal with the assets of a loved one. Ask them for a referral of a probate attorney. So that way you know exactly what's supposed to be done.
Yeah, and one other aspect to that, I would think that an executor or administrator trying to handle the probate process on their own may very well give rise to some red flags and suspicions by the other heirs. Why would you want to do this unless you're going to probably misappropriate funds for your own personal gain?
Yeah, because you have to be very transparent with that process, you know, and unfortunately, when you're talking about someone's decedent's assets, you know, it can be very substantial, and people could be expecting funds or whatever the case is. There could be some jealousy that they're not the executor, right? And that's going to just channel some other emotions. So if you don't know what to do, you know, at least try to get some guidance. And there might be some things out there that are income-based, right? The Birmingham Volunteer Lawyers Program, you know, or there are clinics and things that might be able to give some guidance on how to make a will, or how to make sure that people in the will know that you have a will, how to prepare for your death.
Great job. I wish we had more time, but we've got to wrap it up here. Thank you so much, George.
I know if the viewers like me at home right now, I took notes. I got plenty of notes, so that meant, Joy, you gave us some great information. Thanks so much for stopping by, and thank you for stopping by, the attorneys as well. We'll see you next time.
Thanks for watching The Attorneys, sponsored by Hollis Wright.